Hello and welcome everyone to the National Veterans Small Business Coalition's virtual training series. Today, I am thrilled to have with us Cy and Lauren from PilieroMazza, and it looks like Cy and Lauren, we're going to be talking about legal challenges for government contractors with all of these recent executive orders. I'm really interested to learn about how to navigate those, so I'm looking forward to this first part of several series that PilieroMazza will be having for us over the next several weeks. And so with that, Lauren and Cy, I'm going to turn it over to you and let you guide us through all of these wonderful executive orders that have been coming out.
Yeah. Thanks for having us. I'm Cy Alba. I'm a partner with our government contracts practice and also really in our corporate M&A group. So happy to be here. There's been a lot going on, as you said, I'm sure as everyone knows, since the new administration took over. Yeah, we're about halfway through the year, and there's still a lot of moving pieces here. And I'm here with my partner, Lauren, who kind of leads up our claims and appeals practice, because that's where a lot of these things have focused, and there's been a lot of impacts on contractors. So, Lauren, you want to introduce yourself?
Thank you, Cy. So I lead, like Cy said, the REAs Claims and Appeals Practice Group. So I focus particularly on disputes under the Contract Disputes Act. And that covers really any issues that arise that deal with contract administration. So that is involving a lot of stop work orders, terminations that are flowing from these executive orders. So we have been very busy since the change in administration, and we're looking forward to talking through some of these challenges and how we can help contractors ensure that they get max recovery associated with a lot of these impacts.
Okay, great. Well, I'm going to go into what I call stealth mode, and I'm going to let you both kind of take it from here.
Thank you so much. So first, we're going to talk about some of the major executive orders that were issued most recently since the change in administration. And then we're going to talk about the major uptick in stop work orders and terminations that have been impacting a lot of our clients' performance and a lot of government contractors in general. So I'm going to just talk about a few of these. We know that there's been a flurry, but the big item executive orders that are worth talking about. So the first one is that they revoked 78 executive orders determined not to align with President Trump's policy objectives. So this includes executive orders which furthered policies on COVID-19, climate, diversity, equity, inclusion, and immigration. The Trump administration also rescinded Executive Order 14055, which covered the non-displacement of qualified workers under service contracts. And that is initially it required certain federal contractors to provide a right of first refusal to employees of a predecessor contractor. So that no longer exists. I think we're all pretty aware of Executive Order 14173, which ended illegal discrimination and restoring merit-based opportunity. So this declared race and sex-based preferences illegal and largely eliminated all DEI and affirmative action-based programming for both the federal government and its contractors. And what flowed from this executive order was a lot of our clients reaching out to discuss changes in their employment policies. So it's really important that you take a look at this executive order, understand what your employment handbook says, and whether or not you need to implement any changes to those policies. Another executive order is 14151, which ended radical and wasteful government DEI programs and preferencing. This is the same type of, just covered that. And then the last one is Executive Order 14275, restoring common sense to federal procurement. And this was a reform of the 40-year-old federal acquisition regulation that we are all paying very close attention to. We are sending around weekly updates due to the updates that are being implemented as a result of this reformation. So it's really important you're taking a look at that and understanding the changes that are being made to the FAR and the impacts that they are having. And then finally, rescinding of the minimum wage executive order 14026, which had set the minimum wage at $17.75. So now that means executive order 13658, which set the minimum wage standard at $13.30, is still in effect for certain contracts. So I'm going to move on to the next slide. So we're talking about America First trade policy directives and tariffs. So this policy directive highlighted the president's intent to establish a robust and reinvigorated trade policy that promoted investment and productivity, enhanced our nation's industrial and technological advantages, defends our economic and national security, and above all, benefits American workers, manufacturers, farmers, ranchers, etc. So what drove that is the new tariffs that were imposed on Mexico, Canada, and China. As you can see from the slide, there's been some fluctuation in percentages on energy products, Chinese products, steel and aluminum imports. And towards the end of the presentation, we're going to talk a bit about the tariff impacts and some questions that we've been getting from our client base about how to adjust and just make sure that you are ready for some of these tariffs that are being implemented or that are pending, and how to communicate with your suppliers to ensure that, or at least abate or lessen the impact. So we'll touch on that as well today. And then,
one thing just I want to
ahead,
note, like before we jump into the more stuff too, is I've talked to some folks in the administration and on the Hill on both sides, and there does seem to be a pretty strong appetite to sway things back and forth. And so I think one thing government contractors should be ready for, probably for the rest of my career, which I think, unless something changes drastically, so maybe another 20 years, is that there's going to be pretty large shifts. If a Democratic administration comes in, they're going to move pretty rapidly to unwind. There's a lot of political angst, obviously, right now. And if a Republican administration comes in after that, they're probably going to push everything back. So people should generally be prepared for some whiplash here, potentially every 4 years, depending on how things go. Maybe every couple of years, depending on what happens with congressional stuff, because there's been some big thoughts there that they might push for things depending on how majorities change. So it's going to be a little bit of a tumultuous time. And so just be aware of that. And even on some of these tariffs that Lauren just talked about, there's been a lot of changes even in the past couple of days. And I think things in the next week or so we might hear about. So this is like a rapidly evolving process, and I don't necessarily see that changing in the foreseeable future. So just be prepared.
So moving on to talking about the impacts of DOGE. So this has been the biggest driver of the stop work orders, terminations that our client base has been experiencing. It all relates to this federal spending overall, and tied to the executive order that was issued on February 26th that was aimed to increase transparency and accountability in federal contracts. And it's been driving, like we said, a lot of these stop work orders so that DOGE and certain agency personnel can do internal audits and evaluations of contracting performance and also pricing. Agencies were required to justify and publicly document all payments, review contracts for cost savings, and issue new procurement guidance. So what has been coming out of that is that we've had a lot of contracting officers reaching out to our client base to get more information as far as pricing, to see if they would reconsider applying certain discounts moving forward on option years. So the way that performance is fluctuating and costs are fluctuating, and understanding your pricing and your rights when option years come up, it's really important to know how to respond to the agency and understand your rights and disclosures of information. It also, this evaluation process also gave agencies 30 days to review existing contracts and grants for potential termination, modifications, and renegotiation, which was driving a lot of these letters. We also our client base is experiencing a flurry of terminations. It started first with consulting-based contracts. It's now spreading a bit to other areas like commercial items. So really important to take a look at your contracts, understand your rights, understand terms and conditions associated with terminations and stop work orders, so that you know how to appropriately respond to these types of actions that are being taken on these contracts. We're also seeing temporary freezes on new contracting officer warrants, which is very much so slowing procurement operations. We have clients that have received a lot of stop work orders because of cessations in funding. And also the fact that there's a lot of turnover between contracting officers and those that are being RIF'd. So again, just really important to understand and communicate with your contracting officer to understand their position and their role, and that you have the right to seek adjustment of costs associated with the stop work order to the extent that you receive one.
And even with procurements, I've seen contracting officers now asking for discounts as a matter of course. It's now happened a few times in the past couple of weeks. And you should know they're not necessarily asking you because your price is too high. It might have nothing to do with you personally. It's almost reflexive, I think, based on like just DOGE mandates to try to squeeze people. And so I've seen clients that have reduced their price substantially, and then the award goes to someone that in one case was literally 3 times higher than them. So you need to be, and it's difficult to challenge those sorts of actions because you took the business decision to lower your price. So know that when they're asking you for certain things, it might just be reflexive and not necessarily something they're targeting you about. So just be aware of that.
Yeah, it's becoming more of like an internal policy, I think. And to Sai's point, you don't always have to provide a discount. It can be more of a conversation with the contracting officer, understand the driving aspect of the questions for discounts and pricing and breakdown. But that doesn't mean you automatically have to provide a discount. So that's a good point. So like we've been talking about, what has come out of a lot of these actions and executive orders or stop work orders. They've been issued to give contracting officers and agencies time to reevaluate, understand where the funding is going, determine whether they want to turn the contract back on, whether they want to seek a discount, or whether they want to terminate. So at a high level, what we've been talking to our clients about is providing immediate notice to the contracting officer of your intention to file a request for equitable adjustment. So the stop work clause that should be in your contract and that should be cited to any stop work notice is FAR 52.242-15. So it's really important to take a look at your contract, see if that clause is in there, because we have seen in some instances, especially in commercial items contracts, where contracting officers are issuing stop work orders, and this clause is not in the contractor's contract. So they technically do not have the right to actually stop your work. You can push back. In certain instances, we've had clients push back on any stop work issuance without that clause being in their contract. It's created them some leverage to work through the issues with their contracting officer and negotiate some form of adjustment. So again, really important to take a look at your contract, see if that clause is in there. If it is in there, what you do have a duty to do is you obviously have to stop work, and you're required to mitigate your costs and record that proof of mitigation. So the example I always like to use is, say you're leasing a facility for performance. You get a stop work order. Are you required to continue to pay those lease payments and then pass that cost along to the government? You should be able to pass those costs if you cannot mitigate that situation. So you are required to at least, try to reach out to your landlord in that type of situation to try to see if you can at least reduce the lease cost, potentially get out of the lease for a certain period of time. If you cannot do that, you can then pass those costs along to the government, because it's obviously not on your company that a stop work is required here, but you do actually have to take those steps to mitigate. The same situation with employees. So you can't just have employees, sitting on the bench. If there's a opportunity for them within the company, like if you can place them on another contract, find another avenue for them to perform, you need to do that. Unless that employee is highly specialized and you have no place else to put them, again, there is a duty to mitigate under the stop work clause. So it's really important you understand that and start implementing that right away. The other thing that we've been telling our clients is obviously you need to make sure that you're documenting your efforts and implementing the stop work. So that's either, furloughing employees, trying to, like I said, negotiate down certain costs, standby costs, but just making sure that you are doing that in writing and documenting that effort so that you can then pass that along to the agency when you're seeking an adjustment under FAR 52242-15. The other thing that you may want to consider, so some of our clients have reached a boiling point with submitting a request for equitable adjustment under 52242-15. So under that clause, once the stop work order is lifted, you have 30 days to submit a request for equitable adjustment, which covers all the costs that you incurred from the date that the stop work order was issued up to the date that it was lifted. So that request for adjustment has to go in within 30 days from the lift of the stop work. If those costs are significant and you can no longer carry those costs, you may want to consider filing a claim in lieu of an REA. And the reason being is that when you submit an REA, there's no FAR requirement for the government to respond in a timely manner. So, in certain instances, we've had clients that submit an REA and it can sit out there for 60 days, 120 days, even a year. So if you reach a point where you can no longer carry that REA cost, we suggest that you file it as a claim under the Contracts Disputes Act, because under the CDA, the contracting officer has to respond within 60 days. So, what I've been telling clients is that they want to set an internal deadline as to when you're no longer ready, able to carry that cost, elevate the issue to a claim, get that out to the door to the CEO. And then finally, the last big high point we're recommending to clients is reserving your rights to challenge the directive, the actual stop work directive. A lot of these stop works and terminations, as I'm sure you all know, have been challenged at the courts. Some decisions have been favorable where they're overturning termination actions or overturning stop work orders. Others have not. So in the instances where the terminations and stop works have been overturned, making sure that you reserve your rights to challenge that determination, using that court order to your advantage to then get your contract turned back on. So again, really important to reserve your rights there. We've been drafting that reservation of rights language for a lot of our clients. It's been helpful in certain cases where the district courts, appellate courts have been overturning some of these actions by the Trump administration. So again, really important that you get that language out there and over to your CO. So Sai and I are going to talk about just some key questions that we have been asked by our clients. They're pretty common since the change in administration, and just some pointers for moving forward over the next few months. So one of the big things that we've been seeing is just the non-payment of invoices. It's for various reasons. Some examples are, with USAID. USAID was shuttered immediately with the change in administration. So a lot of invoices out of USAID submitted to USAID have been sitting for quite some time. So what do you do if you have an invoice that hasn't been paid due to the contract reviews from DOGE or funding restrictions? So the first thing you want to do is take a look. Have your invoices been fully documented? Are they compliant with contract terms? Are they sitting because of some compliance issue, or they were wrongfully uploaded into WAF or something to that effect? If there's no issue with the actual invoice, say it was submitted, it was approved, but it's just languishing, then you want to consider how long has it actually been sitting out there. Under the Prompt Payment Act, invoices have to be paid within 30 days. So if there has been no payment within that 30-day window, you're actually entitled to Prompt Payment Act interest. So it's really important that you reach out to your CO, remind them that Prompt Payment Act interest is beginning to accrue due to the non-payment within 30 days. Same thing that I talked about on the stop work REA. If this invoice has been out there and you can no longer carry that cost, one thing to consider is filing a claim under the Contracts Disputes Act. We have had a few clients, again, using USAID as an example, that have, $1 million+ worth of invoices sitting out there at USAID, a cost that they can no longer carry. It's making it financially untenable. What do? What we have been suggesting is that they file a claim under the Contract Disputes Act. It requires a response within 60 days. On unpaid invoices that have been approved, the entitlement piece, like this idea that, are you entitled to this money, is pretty clear. The government has approved your invoice. It's just sitting out there. So the entitlement piece of the claim is easy. It's just a matter of getting somebody to pay attention and get it paid. So oftentimes the claim is actually that attention driver. It's being submitted to the CO. They have to respond within 60 days. So again, we've had some clients do that, and they have been able to get some movement on invoices as a result. how can I escalate my claim without jeopardizing future government work? So this is a really big point as far as it's a business decision, right? If this is work that you've been doing for 15 years, you have a really good rapport with the contracting officer, you don't want to ruffle feathers, then maybe consider just trying alternative avenues to trying to get that invoice paid. If the relationship is a bit broken, if there's concerns that the agency itself is shuttering, like with USAID, with CFPB, then it may be time to get that into the claim process. There's a sense of urgency there. So you really need to weigh your options as far as and your relationships under the contract before you escalate the issues to a claim, because it does put you in an adversarial position with the agency. So really important to understand, what's more urgent, getting paid or maintaining that relationship.
Yeah, because unfortunately, and I've talked to folks about this a lot recently, both on the private sector side, with just contract subcontracts, and with the government. At the end of the day, at least in this country, right, even a perfectly written contract doesn't stop someone from taking an action, like breaching a contract, right? It's similar to, I use the example, people are like, well, murder is obviously illegal, right? But any of us could just murder someone tomorrow or right now, right? You could do that. Would there be consequences? Probably, hopefully, right? To keep society moving. In this context, or in any breach of contract context, even if your contract is perfectly written, someone can always breach any term, and your recourse is to file a lawsuit. And in the case of the government contractors, when you're going after the government, they write the rules. And so, as Lauren was saying, the Contract Disputes Act specifically says what you have to do in order to actually go after the government. And it's a multi-step process, and you have to follow that process. If you don't follow that exact process, your claim will be thrown out if you just try to sue or you take some other action. And if you don't want to follow that process and go through quote unquote litigation, then it's just a negotiation. It's just talking to them, hoping something will change. And that's just the unfortunate reality of you're being forced almost to choose the relationship versus trying to expedite payment in the only way that the law allows. It's extremely frustrating, but that is the way the process has to take place. So just be aware of that. There aren't too many options.
Right. And one other point that I didn't make before is one of the other benefits of filing the claim is you get interest under the CDA as well. So you get Prompt Payment Act interest. It's limited to a certain window of time, but then once you file your claim, CDA interest attaches as well. So if your invoices are sitting out there for multiple years, hopefully that's not the case, you're also entitled to CDA interest. So there is some benefit of getting that claim out sooner than later. So just something to think about as well. So question 2, if my contract is terminated for convenience or I receive a stop work order, what rights do I have? So going back to the point I made before about reserving your rights to challenge the termination or stop work, that from my perspective should be an automatic reservation. If you get a termination, if you get a stop work order, we should always be communicating to the contracting officer that we are going to abide by that directive. However, we're reserving our rights to challenge that directive should it be unwound. So like I said, a lot of, some of the courts have been unwinding some of these actions to the benefit of contractors. So we have been able to then get those contracts turned back on under this reservation of rights. So something to just keep in mind. And then as far as what type of cost can I recover under these circumstances? So I'm going to talk a little bit about stop works and about terminations for convenience, as they're a little bit different, but similar in certain ways. So when you get a stop work order, that's obviously stopping performance for a certain period of time. Under 52242-15, it cannot exceed 90 days. So those stop work orders are being issued in instances where they're doing funding reviews, or DOGE is, in the building and doing a review. Sometimes those stop work orders become terminations for convenience. So say DOGE comes in, does a review, they issue a stop work order. 60 days later, they realize that they want to terminate the contract for convenience. So the stop work REA covers your stop work period of time. So that is when your performance is in this like cessation period, it's pending. You have people on standby, but you haven't actually like dissolved the program. Those types of costs can be submitted in a stop work if it's lifted, but those stop work costs can also be rolled into a termination for convenience proposal that is a little bit separate of a process. So again, stop work, those costs get submitted in REA. If it gets lifted, if it gets terminated, those costs then get rolled over into a termination proposal. So if your contract actually gets terminated for convenience, what you are required to do is submit a proposal, a settlement proposal for all the costs incurred that are left unpaid at the time of termination. So that covers not just performance costs that are unpaid. So you can submit all, you want to get all your invoices out that are unpaid over to the government in your proposal. And you also want to get your wind down costs. So that's, any costs incurred for winding down that particular contract. And that includes administrative time spent on, notifying subcontractors, severing employees, HR time, administrative time, talking to your legal team, talking to HR. And then you're also entitled to accounting and legal fee recovery. So if you engage, us to assist with your proposal, the time that we spend on preparing your proposal is a recoverable cost as part of your termination proposal. So again, really important to understand what your costs look like and the certain cost categories that you can recover. But if you can reasonably justify a cost associated with the wind down of that particular contract, you can try to include that in your proposal. So how do you ensure your documentation actually supports what you are submitting? So, I have had some clients approach me about submitting a proposal and it's just simply a spreadsheet. And what I've had to do is reach back out to them and say, well, we can't just submit numbers to the government. They're not just going to write a blank check because you sent them a spreadsheet with a bunch of numbers in it that covers administrative time and severance. We actually need to show proof of those costs. So whether that's invoices, whether that's an employment policy that mandates you make severance payments, all of that information has to be provided to the government to actually get paid. The other big practice point is administrative time that you are spending on winding down the project, talking to legal, talking to HR, talking to your accountant. That has to be contemporaneously recorded with descriptions. Another thing that clients are doing is they're sending me their total time spent and a rate associated with that. The government is not just going to pay that. They actually need to see what you were doing during those hours. So making sure that you are detailing the time that you are spending, winding down as a result of a termination, really important that you record that as part of your proposal when you do submit it. How long do you have to submit a request for adjustment, termination for convenience proposal? So like I said, if you are in the stop work period and that stop work gets lifted, you have 30 days to submit your request for adjustment. If you receive a stop work and then you get terminated, it is very dependent on the termination for convenience clause that's in your contract. So if you are operating under a firm fixed price contract, if you're operating under a cost reimbursable contract, typically you have a year to submit your termination for convenience proposal. If you are operating under a commercial items contract, there is no deadline to submit the proposal, but I do recommend to our client base that they submit within that year time frame. But what we have been seeing, which is irregular, since the change in administration and the flood of terminations for convenience that are being issued, that they're putting strict deadlines to submit these proposals. Some agencies are imposing 7 to 10 day windows to submit. Some are imposing 30 to 60 day windows to submit. Although these deadlines are in essence arbitrary because they're not required under the FAR, what we have been telling our clients is we're encouraging them to try to abide by those deadlines because they are likely being driven by some factor within the agency, whether the contracting officer is getting riffed or the contracting officer is leaving, or there's kind of an agency shakeup or an internal, a review that's being done by DOGE. There's typically a reason why they're putting certain timeframes on the request for these proposals. So if it's possible, we're suggesting to our clients that they abide by those deadlines or at least ask for a reasonable extension if it's something that you don't believe you'll be able to abide by. So, for instance, we had a client the other day reach out that they were put under a 30-day time frame. They explained that there's just no way that they were going to be able to meet that just based off of other projects that they have ongoing. So we put together an email for them to reach out to the CO seeking an extension for 14 days. They got an additional 2 weeks. And, now they have a little bit more cushion to get their proposal out the door. So again, because these deadlines are arbitrary, it's very reasonable to seek an extension. Some cases, the contracting officers have denied that request, but if it's possible to get it done within the time frame that is set in your termination for convenience notice, try to meet that deadline if you can. So question 3, can I mitigate financial losses due to a stop work order or contract termination? So what immediate steps should I take to minimize additional costs? So like I said before, there is a duty to mitigate that's built into both of these concepts, whether it's a stop work or termination. You can't just, if you get a stop work order, keep people on your bench and not find other work for them, or, you can't just sit there and not make the effort to return equipment or try to negotiate out of your lease. You do actually have to take these types of steps to mitigate costs. Otherwise, the government is going to take issue with it and really fight you over certain payments. So again, making sure that you're evaluating your contracts, understanding your underlying agreements that you have, like those leases that you may have in place, or equipment purchasing invoice quotes, or arrangements that you have to potentially return equipment, is really important that you understand what those arrangements are like so that you can potentially mitigate if you have to. And negotiating with subcontractors to reduce liability, that is something that you actually have to engage in if you can. So the government may come back and say, well, did you reach out to your sub to see if you could, lessen the blow here? And if we don't have proof of our attempt to mitigate, that can become problematic. The contracting officer will ask for that. So again, really important that you understand those relationships that you have under certain projects and whether or not you can mitigate that situation. And then, are there specific FAR provisions that allow me to recover mitigation costs? So the time that you are spending trying to mitigate these costs. So like I said before, if you are reaching out to subs, if you're reaching out to suppliers, really important that you are actively recording that time, because the time that you're spending to do that is a recoverable cost under the stop work clause and under the termination for convenience clause. So reminding your employees that that time should be recorded is really important. What I do suggest is, if you do get a stop work or termination for convenience, that you set up a separate cost code in your accounting system so that this time can be accurately recorded and tracked. It's been helpful to a lot of our clients to do that, and it's also made it easier for them to negotiate with the government to recover those types of costs.
And the larger some of your costs are to the amount of the contract that's been spent, you should be prepared to really fight harder for that, because the government's going to push back. Like, for instance, I had clients that were doing conference services where they're managing the production of a conference. Most of the costs that they've incurred that they weren't able to mitigate, although they tried with hotels and other things, caterers, that kind of thing, those costs are vastly higher, multiple times higher than what the actual contract price is, because all of those costs are usually paid by attendees and sponsors of the conference. When the government canceled the conference, they canceled all of the funding mechanisms to cover the costs, and therefore the government, instead of spending $150,000 on a conference, is now stuck with a T4C claim for millions. They are going to fight very hard on that and probably try to make arguments that it was unreasonable, which, as stupid as it sounds, it was unreasonable for a contractor to enter into agreements with various vendors or with conference providers or with hotels or whatever without having some sort of termination clause. So they're going to fight you very hard on that, which makes it more important to document all of the mitigation efforts that you undertook, trying to get, if you can get any sort of credit for future conferences, providing that to the government, like anything you can do to show you tried to mitigate the cost and tried to help the government or try to get them credits will give you some sort of goodwill. And it's incredibly important to push as hard as you can for that, because the case law is pretty strict on your ability or the requirement to mitigate.
So question 4, what costs are allowable under a stop work order or termination for convenience settlement? So I'm going to touch on some that we may not have talked about. So direct and indirect costs, what can I claim? So you can obviously recover direct material, direct labor, indirect costs like G&A and overhead. All of those costs can be recoverable as long as they're justifiable and supported by documentation. How do I calculate overhead and administrative expenses for reimbursement? So biggest point is to take a look at how you've been calculating it in your proposal. It's a number or percentage that the government is accustomed to or comfortable with or has approved through the proposal process or in prior contracts with your company. Those are the types of percentages and markups that you want to be including in your proposal. What settlement expenses can I include in my claim? So this is settlement expenses is tying back to what I was talking about as far as administrative time, also accounting, consultant, and legal time. So settlement expenses is a term that's used to cover kind of the assistance that you're getting in actually preparing that proposal. It's a separate cost category that you can include in a stop work submission or in a termination for convenience settlement proposal. So really important that you track that, you understand that those costs are recoverable. They can be included as a separate cost category beyond just direct material, labor, and indirect costs. Are any forms required by the agency to support certain costs? So yes, this is why it's really important you understand what termination for convenience clause is in your contract, because that type of clause is going to drive certain forms that you may have to submit. So really important to understand that if you are operating under a commercial items contract, which is 52-12-4, you do not have to submit any forms. It's not a requirement. It's a little bit looser of a process and less formal. You don't have to abide by cost accounting standards. So commercial items contracts don't require any forms. If you are submitting under a firm fixed price contract, which typically termination for convenience clause is 52.249-2, you are required to submit a standard form. You want to confirm with your contracting officer what type of form that they are requesting, whether it's standard form 1435 or standard form 1436. But those are the two that are required under firm fixed price termination for convenience clauses. And those actually lay out the cost categories that you can recover as part of a proposal. So really important, even if you haven't received a termination, just take a look at those forms to see like what the cost categories are and how those are structured. So we'll save you time on the back end to the extent you may receive one. If you are operating under a cost reimbursable contract, standard form 1437 is what is required to be submitted along with your proposal. Take a look at that. It's structured a little bit different for cost reimbursable time and materials types contracts. There's like a cost category for fee, but it is a bit different. And also another reminder, really important that when you're preparing these proposals is if the cost is significant, really important to get your accountant involved, get legal involved so that they can do just kind of like a sanity check on what you're putting together in your form and getting out the door. Reason being is that these forms require certification by the company representative. If any information in these forms is inaccurate or improper, you could be facing some form of false claim violation. So again, really important you take a look at the forms, understand the cost categories, and have an expert, if willing, take a look at it, because that is a cost that you can include under that settlement expense category. So again, really worth having somebody take a look at it, give it a sanity check before you sign it, and send it out the door. So question 5, if my termination was suddenly rescinded or converted to a partial termination or descope, what rights do I have? So this is kind of a strange thing that has been happening since the change in administration. So typically pre-administration, we would get a client get a termination for convenience and that was the end of it. Because of these legal challenges, because of these DOGE reviews, there's been a lot of weird back and forth where we've had some clients that get a termination for convenience. They start winding down everything right away. 2 weeks later, they get a call from their CEO. Hey, we want to retract that termination for convenience. We want to put this contract back on. What do you think? So what do you do, right? You've already laid people off, you've already returned equipment, you've already tried to mitigate costs. The time that you spend, so if it's worth agreeing to turn that contract back on, the time that you spend and winding down, the costs incurred in that 2-week window where you were, closing out the contract and now it's being turned back on, is a recoverable expense. And it's something that you should consider negotiating with the contracting officer when they reach out to you to turn the contract back on. We've had some clients that would just say, yes, let's do it. Let's get it back on. They sign a modification with a release, and then, they can't recover the 2 weeks of extreme costs that they've incurred trying to wind down the project. So know your rights, understand that if you do get a T4C and they turn it back on, or they ask to turn it back on, that you do have a right to recovery. The same thing with a descope to your contract. So say they descope a CLIN, or they partially terminate a CLIN off your contract. You can recover termination for convenience related costs associated with that reduction in performance. So just because they're writing something off of your contract doesn't mean that you can't recover certain costs under the termination for convenience clause. It's really important to understand your rights, again, that you can recover that. It can be sought through the proposal process. What if you cannot refill all positions or remobilize? That is a conversation you need to have with your contracting officer before you sign anything. Making sure that maybe they put in an extension of your performance period so that you can do that, so that you do have that time, that window of time to refill, so you don't have, pains as soon as you get back into the office, or you again, turn that contract back on. And then again, just understanding that you have the leverage here, right? If they T4C'd you, or they took something off your contract, they want to turn it back on, you can negotiate. Don't just, agree with the CO to agree with them. If it ultimately is a business decision, but if there was significant costs incurred, or it's going to be difficult to get back on board certain employees or get remobilized, make sure your CO understands that and try to negotiate some arrangement through to get that contract turned back on. And if you don't want to turn back on, you also have the right to say no. If the contract has been T4C'd, that is a formal action that's been taken on your contract. Understand that you don't always have to agree with the contracting officer if they approach you about basically turning the lights back on that contract. So again, just understanding your rights and communicating with your CO is really important.
Or potentially challenging too, if you have a competitor, if it's a big contract that should go back out on the street, if they've terminated it, there really isn't a clear mechanism in the law to just turn it back on, despite what they're trying to do. And so if the contract is terminated and then they turn it back on, it's arguably a sole source award. And if they didn't do a J&A, it's arguably improper. So there are other issues that come up there too that could put it at risk, or to protest, or other things of that nature. So there is a decent amount of leverage on some of this stuff, although most people, I think, are just agreeing to just get the dollars flowing again.
So question 6, is there a benefit to filing claims sooner rather than later? So like I talked about before, my biggest suggestion to a contractor is, again, setting that internal deadline, understanding how long you can carry certain costs. So whether it's unpaid invoices, whether it's a pending REA, or even a pending termination settlement proposal, if those are languishing, if you're not getting responses and the costs are significant or actually impacting your bottom line, that is when a claim should be submitted. You have 6 years to submit a certified claim under the CDA. I never suggest to a client that they wait that long. The other risk is not just the financial impact to your company, but it's also passage of time and forgetting what actually happened on the contract. So we've had clients that have waited, 4 or 5 years to submit a claim. The contracting officer is no longer there who actually worked on the contract. Employees are no longer within, the company's team. So it's the benefits of submitting a claim earlier than later are pretty clear, as far as, just making sure that interest is running, that somebody is paying attention to it, and that there's no forgetting of the facts. As far as documentation that you should have in place before filing a claim, claims need to be justified with evidence. So if you are submitting a claim for especially a significant dollar amount, you want to make sure that you are providing email support. So, if you say that you talked with the contracting officer and they changed the terms and conditions of your contract, make sure that you're providing proof of that change. Hopefully you have it in writing, and it's either through email correspondence, meeting minutes, daily reports, something to that effect. But any claim has to be well documented so that whatever story that you are telling to the contracting officer that requires them to pay you or to, adjust something to your contract should be documented, supported by some form of evidence, so that the contracting officer can take a look and say, oh, hey, yeah, that did happen. I see it in writing right here, and I can make that change and make that payment. So another instance is like if that stop work order gets lifted and you submit an REA, making sure that the costs that you are seeking through that stop work period are well justified and supported through documentation. So if you put people on standby and they're highly specialized, you're seeking the costs associated with paying those people for 2 months per se. Showing proof of these highly specialized people and what their salary is and why it costs you that much within that 2-month period, that has to be done through written documentation. You can't just send a number over to the contracting officer. And I know that sounds crazy, but we have clients that have done that in the past and it's been rejected. So again, just making sure that you have that underlying justification, that foundation, so that the contracting officer can take a look, understand why you're asking for that dollar amount or that extension of your performance period or whatever, so that they don't actually have to come back and ask more questions. It just sets that foundation. They can evaluate and make a quick payment. So how does timing impact my ability to access the judgment fund? So filing a claim and the judgment fund have become a more common conversation since the change in administration. And the reason being is that DOGE has been implementing a ton of funding restrictions. And the judgment fund, what it is that at a high level, it's a bucket of money that agencies can use to pay out a judgment. So if you, for instance, have an unpaid invoice, it's been approved, it's just pending in the system somewhere, for example, at USAID. If you file a claim to recover that unpaid invoice, 60 days goes by, you get no response from the contracting officer, you actually have the right to then appeal that to the Board of Contract Appeals or to the Court of Federal Claims. The court or the board can issue a judgment against the agency. So again, in my example, USAID, and say, USAID, hey, you owe contractor X dollars. The agency, USAID, can then they can go to the judgment fund to pay that money, to pay your invoice. So they don't actually have to go back to DOGE or any internal, component within the agency to find those dollars. They can actually access the judgment fund to make that payment. So it opens up some dollars that were, that are not within funding restrictions at that agency to get you paid. So there is, in essence, a benefit if you have a significant dollar amount that's outstanding, filing a claim, then eventually appealing it to the Board of Contract Appeals or the Court of Federal Claims, so that the agency can then access the judgment fund and get you paid. So that is what the judgment fund is. It's not something that we commonly discuss before the change in administration, but it is an avenue if you're willing to consider it and actually get into litigation over it, where the agency can find some dollars and get something paid. So question 7, am I in compliance with the recent executive orders? So this was tying back to the executive order on the revocation of DEI policies, for instance. It's really important that you take a look at those executive orders that we highlight in the beginning of the presentation to understand what your employment handbook looks like, what your company policies look like, so that they are abiding by these recent changes and executive orders that the Trump administration has implemented. The really important part is that you could potentially be subject to a government audit. They are, we have seen some agencies auditing certain contractors and to ensure that these removal of DEI policies have been implemented. So again, really important to have a labor and employment attorney potentially take a look at your policies, understand what these executive orders are saying. To the extent that you do go under audit, it could result in potential termination of contracts. We have had some clients, unfortunately, be audited by certain agencies, the audit has not been favorable, and it has resulted in terminations of certain grants and contracts. So again, really important that you take a look at the policies that you have in place and that they're abiding by these recent executive orders that have been issued. And being at risk of a false claims violation is also a concern. If you are not abiding by these executive orders, if your policies have not been updated, and you are actively working and submitting invoices, getting paid on certain projects at the same time that your policies have not been updated, you do run a risk of a false claims violation. Agency can come after you and try to basically take those monies back from you as a result of your inability to abide by these executive orders. So there's various risks by not complying. And again, just making sure that you do an internal audit of all employment handbooks and internal company policies to make sure that you are up to date and are complying with these executive orders.
Yeah, and I think given timing, I know there are some questions too that maybe we should see if there's some questions we can take from folks and kind of go forward and kind of wrap things up given the time.
Hi, I do have a couple questions from what you've presented so far. So some of the things that I'm gleaning from the communications that you're trying to get across to the business owners is that communication with the contracting officer is critical. You need to be able to stay in communication with the contracting officer to find out whether it's a stop work order or if it's a descoping of a particular contract, as well, not only the contracting officer, but the technical, or what I like to call the programmatic line individual as well. They may be able to give you some additional insights in that. Business owners really have to understand, they need to be in compliance with the new the executive orders that are coming out, and really understand the FAR regulations and know that they have a plethora of resources available. Some of the questions I had at the onset of the presentation is, under the America First Trade Policy Directive and tariffs, do you anticipate that this is going to drive an increase in manufacturing and actually tech development, I'll say cyber initiatives, back into the United States with the U.S. workforce? Have you heard anything around that at all, Cy or Lauren?
I'll say that I have seen a number of clients with an uptick in some of the use of OTAs or growth in some of the OTAs. And I've seen an uptick in companies that have cyber work or are looking to get into those areas or have potential products and services like AI products, those sorts of things that they think would be of interest to the new administration, that they're looking to go into some of those more non-traditional sources of funding, and that there have definitely been an uptick and a push for that. At the same time, I've also talked to folks on the Hill and on the Republican side, so same party, that are a little worried about the use of, or just a continued heightened use of things like OTAs, because they can't track the funding, or there's fear that it'll just be used as a sort of end run, and that Congress doesn't have the same sort of oversight or easy access to oversight over some of these non-traditional procurement vehicles as they do over some of the more traditional side. So that's sort of an interesting avenue, because I know there was a big push to do things faster and more efficiently. At the same time, faster and efficient usually means less oversight. And there's somewhat of a clash there that I'm starting to see and starting to hear from people on the Hill, which also I think leads to some of these FAR changes. I think there's going to be some pushback to the FAR changes, and I've talked to people on the Hill about that as well, because the more streamlined you make something, the more susceptible you also make it to fraud and abuse and certain things that happened in like the early 90s where people were taking jobs in order to push contracts to contractors, things of that nature, like government officials that were agreeing to take jobs after they leave the government if they perform certain actions. So the faster you do something, the less oversight you're going to have. And I fear there's going to be this pendulum swing where there's this knee-jerk reaction to go certain ways. We're going to see all the problems. It's going to swing all the way back. We're going to rewrite the FAR over the next 20 years the way it's been in the past 20 years, where every time something happens, a new provision is added because we strip so much out. And it's just this endless cycle of forgetting history. So I guess we'll see how things shake out. But there has been a push, but now a little bit of a backlash as well already.
So if I were a proactive business owner, knowing what you just said, I may approach a contracting officer or a technical line programmatic, you know, in the tech transfer or manufacturing, and say, I have a system, internal processes and system where I track expenditures by, you know, by initiative or, you know, by manufacturing line, which will help you in obtain funding from Congress or obtain you know, additional funding for your program or project that you are seeking either R&D for or manufacturing or whatever type of contract work. So as a business owner, I ought to strategically, I'm thinking, this is in the world of Marie's brain here, thinking that I ought to make sure that I am tracking expenditures and also cost savings and, you know, ROIs on anything that I am supporting the government for, because that could help me get additional funding or it could help me get additional contract work. Is that somewhat of an okay thought process, do you think? Or is it, you know, trying to be proactive instead of reactive, you know, given the current marketplace? Am I off base?
No, I don't think so. And also showing joint investment, because if it's saying, look, if you procured XYZ system or product or development of a product, as SBIR is really supposed to be, or STTR even, or even OTAs, are supposed to be really for development of something new, right? Not something that's in the bag already and you're just looking for other funding. So if you're telling them, look, here's this innovative, forward-thinking, you know, future-looking product or service, that's been hot topics. And on top of that, SBIR is relatively low funding. And when it goes to phase 3, you're supposed to be getting outside investment, which is reducing the cost of the government. And on the OTA side, to the extent that you can show that, yeah, you're getting certain funding for something, but you're also bringing a lot of R&D to the table, talking with them too about the certain data rights issues that they could get and the return on the investment. Also, I've talked to folks in the Hill about the idea that small business procurements, and not just SBIR, STTR, but just generally investing in small businesses, which OTAs, non-traditional contractors, small businesses are automatically non-traditional, that those companies, the money that you spend on small businesses is money that is reinvested in the US. They're not publicly traded companies with a bunch of foreign investors that own large swaths of the business that are going to get either dividends or increased value. The increased value is going to be right here. It's like America first, right? So those sorts of ideas as well, I think, is a good thing to show and to push, that you're saving money, you're being efficient, you're bringing advanced technologies, and you're doing it here with American citizens and with employees here in the US.
Okay, great. And so another question I had ties with the pricing and with DOGE, you know, the process of discounting contracts coming into play now. It would a better strategy for a business when they're in conversations with DOGE or the contracting officer, when they come back to them saying, hey, can you give me a discount on this, is to take a stance of best value when it comes to the contract. What I am providing you is pricing, not only adequate pricing, but best value to ensure success of this particular mission or this particular initiative taken, that the government has come to me asking for assistance on, or is what's going on with the contracting officer and DOGE saying, hey, we need discounts. Is it a fishing expedition, or are they really trying to find waste, fraud, and abuse? Or are you kind of seeing a blend of everything?
I would say it's a blend. I mean, it's hard to truly understand the driver across agencies, right? I think every agency is operating with DOGE differently, or at least that's the way that we're kind of seeing it as far as the questions that are being posed, the breakdowns that are being requested. But it comes down to a business decision for the client. We've had some clients that really push back and say, to your point, like, this is best value. We submitted our proposal 3 years ago. Nothing's really changed. Our profit margins are thin. And we just cannot give you a discount. And then we have other clients that are, very willing to appease the agency. They want to keep this work. They want to maintain that relationship. And it's really important to them to provide, even if it's a small discount, to work with the agency and see what they can do. So as far as the underlying ask and why it's being asked, it's a little unclear, but I do think in some instances it is a fishing expedition. They do want to root out some fraud, waste, and abuse. But then in other instances, it may just be like an internal policy where they're just asking everybody and just hoping maybe one of those questions will stick and that a contractor is willing to make a discount.
Cool. So a really strong takeaway for business owners is to really know your margins, to really know your profitability, what your margins are for each of the types of contract work that you're going after with different agencies. Those may vary from one agency to the other, again, based on the scope of work, but they really need to know this is as low as I can go, or the type of work that I'm performing really is best value, again, based on the industry area that the business is operating in. So
and educate them too, because some of them are asking for discounts, harboring under the misimpression that you're making 30%, even in IT VAR contracts where you're making 2%, and they just don't understand the industry. I've seen that too. So
yeah, and so that's because a lot of people are coming from industry and applying industry standards, and so to make sure that the business owner, again, it's going back to that conversation, right? Communications. This is why things have transpired, and this is we're already, based on what the government needs with regards to this particular program. I'm giving you the best value and the best quality of work, and be able to substantiate it, not just say, hey, but have the backup documentation to support it. It's kind of what I'm hearing. So that's it for my questions so far. So I think oops, sorry. It's okay. So I think to kind of recap, the takeaways are, again, communication, and we're going to continue with the questions. And so Lauren's popped up question number 8. And so Maria is going to go back into stealth mode here, and we'll pop back in with additional questions. So take it away, Lauren.
Great. Thank you, Marie. So moving on to question 8, this again is going to touch on some stuff we've already been talking about, but just how do you best prepare for a DOGE contract review? We've been, like I said, seeing a lot of these, and just understanding how you respond, how you communicate with your contracting officer, what contracts could be at risk, which ones are not. So what we've been seeing is the kind of first round of review was really focused in on consulting contracts. Now we're starting to see that kind of shift to commercial items-based contracts under certain thresholds. We do think or assume that a lot of these reviews are being run through AI. So it may not be that they're targeting you for a certain reason. It really is just that they ran all these contracts through AI, yours got flagged, and now they're asking questions or potentially even seeking a discount. So could my contracts be at risk for modification or cancellation? This is a very lawyerly response, but it depends, and it's probably eventually going to be looked at. I don't know if it's going to run through a DOGE review and where they're going to be following up with questions. But again, we do think it's being driven through by AI. So it is really hard for us to know what is the true driver. But like I said, we've been seeing a pattern of consulting and commercial items contracts over the past few months. How can I demonstrate compliance with federal regulations? We've had certain contracting officers reach out for certain policy information, for certain pricing information and breakdown information. So, just making sure that your policies are in line, that you have the documentation to support, that your accounting systems are up to date. Things that you should be doing as best practices, do them now if you have not done these types of internal audits within your company, so that if you do get asked questions about pricing or about documentation and your accounting systems, that you can then easily present that information in writing, that you have appropriate structures in place as required under the terms and conditions of your contract. Same thing, what proactive steps should I take to protect my business? If you have not done an internal audit, do that now. Understand where your pricing is coming from, understanding your breakdown, making sure that your employees understand that as well. Really important to take a look at your employment policies and handbook, so that you are prepared to the extent a DOGE review does come your way or there's a discussion over your pricing, so that you are best prepared to respond to those questions and that you have the support to do so. Question 9, how should I respond to foreign assistance review surveys and data calls from government agencies? What information am I required to provide? How do I ensure my responses align with contractual obligations? Should I be concerned about disclosing sensitive or proprietary information? So, these are all really important questions. As far as information to provide, if the government is asking certain questions that align with your contract and the requirements that are built into your contract, you are likely required to disclose that information. We've had some clients reach out with concerns about providing price breakdowns. Again, if it's something that was built into your proposal, marking that when you do turn it over as proprietary and confidential and not to be released outside of the U.S. government is really, really important. Thinking through, in case there's some type of FOIA request to the agency that may be adjacent to your contract, mark. Make sure that you are marking things that you are disclosing to the government as part of these data calls. Again, ensuring that your responses align with contractual obligations. Take a look at your scope of work, take a look at your PWS, statement of objectives, understanding what is required of you. And if there is, some nuance or ambiguity, communicate with your contracting officer before you just start sending everything over to them, or, to a particular agency or requester. Understanding your rights. If what they're asking for does not align with your statement of work, PWS, or statement of objectives, push back. Have them provide a justifiable reason for why they are asking for this. Does it align with the FAR? Does it align with case law? Before you just turn things over. And then as far as disclosing sensitive or proprietary information, if it's like a subcontractor's information, making sure you're getting consent. And also just, again, marking things appropriately, ensuring that it aligns with your contract. If it seems like it's out of scope, it's an unreasonable request, pushing back, communicating with your contracting officer about your concerns, or even involving legal to take a look at, what you are thinking about disclosing, to understand whether it's something you actually do have to turn over or whether you can provide some pushback. But at the end of the day, it is a business decision as far as what data you're willing to provide. But just, again, making sure that it aligns with what is required under your contract.
Or even like broader data calls, or to go back to what we were talking about before, if the government is requesting even like discounts, which I know is on earlier slides, but if you're telling them about your margins, or you can't reduce your price anymore, that could cause them to start asking for certain cost buildup information, which you're not required to provide, But if you don't provide it, they may just terminate the contract and try to go back on the street, or right. There's a lot of actions the government can take that might not be reasonable, but they're allowed to take under the law. So there's always going to be that cost benefit analysis of what you say, how you say it, whether that leads to further requests, how much are you willing to give? If you're not willing to give it, thinking about your responses before you say anything, because if you don't want to provide information, you don't want to have a situation where you plant the seed that solicits the information. So not to say it's all like a chess game, but there is things to think about further down the line as you're having these conversations to facilitate a smoother discussion and not provide more than you want to or can provide.
So moving to our last question. So this has been a hot topic as well, as talking about tariffs. So how do new tariffs and trade restrictions impact my government contracts? So I've had a lot of clients, and this was a big issue around COVID-19 as well. This idea of like supply chain disruptions and rising costs, inflation, et cetera, and how does that impact performance and ability to complete an example, a construction project. What I've been telling clients and what I told them back during the COVID times is that open your line of communication with your contracting officer early. If you feel like there's going to be some pending impact on a particular material or supply that is really foundational to your performance, start that conversation with your contracting officer now. Even if it's a potential tariff, it may not actually happen. We've seen a lot of fluidity associated with these tariffs, but just having that conversation, putting them on notice is extremely important. As far as reimbursement for increased costs due to new tariffs, it depends. During COVID times, as far as supply chain disruptions and impact and increase in materials, we did not see a lot of agencies paying that increase in costs. And the reason being is that is just an eventual impact to any firm fixed price contract, for instance. That's a risk that the contractor takes on. If you have a particular tariff and duties clause in your contract, which not a lot of firm fixed price contracts have, but if you do have it, you may be entitled to an increase in cost through a request for equitable adjustment. So it's really important to understand whether or not your contract has 52.229-3 in it. That is a contract that allows for recovery of after imposed taxes and duties. -6 is the foreign version of that. So if you're doing OCONUS contracts, important to take a look to see if that clause is in your contract. The important thing with that clause is that it has to be after award. So if there's a sense that tariff was coming around by the time you submitted your proposal, but pre-award, the agency could potentially push back and say that's not an after imposed tax. We're not going to pay it. So that, again, understanding if that clause is in your contract. If it isn't, it's likely that it's going to be a negotiation similar to what happened during COVID, where the government is saying, well, increase in pricing, for lumber, for instance, or for steel is always a risk that you take on for a firm fixed price contract. It was important for you to potentially put cushion into your proposal, which you did not. Therefore, we're not going to pay, this increase in price. Another thing that you need to look at is whether you have an economic price adjustment clause in your contract, an EPA. We've had some clients reach out and say, well, our steel products are increasing by 30%. What do we do? But we do have an EPA clause in that contract, and it's tied to a unit price for steel. The problem with the EPA clause is that it is a benefit in the sense that it does allow you to negotiate an increase in any unit price that's tied into that EPA clause. However, it's limited at a threshold. So the client that reached out said that their unit price was increasing by 30%, but the threshold for the EPA adjustment was 10%. So they're losing out on that 20% increase. So, and EPA clauses go both ways. You're entitled to there's a 10% threshold for an adjustment, but if the pricing goes down on that unit price, the agency is then entitled to a discount. So EPA clauses are a benefit, but there are thresholds. So take a look at your contract, see if it has an EPA clause. You may be entitled to an adjustment associated with an increase in pricing, the unit price. But again, that EPA clause can be limited to a particular percentage threshold. So again, important to understand that. But big takeaways are looking to see if your contract has 52229-3, look to see if your contract has an EPA clause. If it doesn't have either of those things, try to start communicating with your CO to see if there's a way that you can get some form of adjustment associated with a tariff impact. But again, we went through this with COVID-19, and there was a lot of pushback on payment for increase in pricing of materials. So it's just something to keep in mind. Best practices, so like what steps do you want to take to potentially abate these issues and these are best practices we are sharing during COVID as well. Negotiate with your subs and lock in quotes. And also pay close attention to the markets in your unit pricing. If you feel like there's going to be some massive influx in pricing on a particular material and you have a subcontractor quote, lock that quote in. Don't, use that quote in your proposal, you get an award, and then all of a sudden the price has gone up 40%. It's really important that you're negotiating with your subcontractors, you're paying attention to the market and understanding the supply chain so that you don't find yourselves, 3 months from now, losing out $3 million because of a material increase.
And push also on your subs that make sure you're looking at your indemnification clauses and your disputes clauses there too, because all too often, even if you have a price locked in and then the sub just breaches, they say, no, I'm not going to do it because I can sell to this guy over here. So I'm not selling to you for that price. If you want it, you got to pay me for it. If your subcontract has a limitation on liability that says the most I'm ever going to owe you is 1 month's worth of the contract or what you've paid me so far, and you haven't paid that much, or 1 month is a pittance, right? Those are generally enforceable. And so you might be getting harmed severely by either having to find another provider or having to take a massive loss on something and not be able to recover from your sub, even though they're breaching the agreement. And it's very, very, very common. I would say the default term on a limitation on liability is that there's no damages for lost profits. There's no consequential damages, which is like the consequence of their breach isn't directly a cost to you. It's maybe the loss of a contract or having to you get terminated, or you have these increased costs, these sorts of issues, right? So you really need to look at everything in your subcontract, and going forward, we know this is going to be an ongoing issue, at least for the next 3.5 years. There's going to be this rolling fight with various countries, almost guaranteed. And so you need to know that. There's also probably an increased risk of termination for convenience, right? So baking those in, making sure you're baking it into your leases that you're negotiating or anything like that. Thinking ahead and really making sure that when you're negotiating subcontracts and working with folks or negotiating pricing, that you're thinking ahead, not just this year, but down the line on all of these issues that are likely going to continue.
Yeah, and that feeds into the Buy American and sourcing requirements as well. Just making sure that you're understanding the subs that you're working with, the suppliers and manufacturers that you're working with, doing an audit of those subcontract arrangements and quotes and proposals and all that good stuff. Just making sure that you are compliant, they are compliant, so that you don't run into any audit issues or even potential false claims issues. So it's just really important that you understand who you're working with. And I think at that point, we are at the close of our presentation. Marie, I'm sure you have some questions for us, so happy to address those.
Oh, I have all kinds of good questions for you, Lauren. And Cy. Okay. My finance brain kicked in, my manufacturing side, because I'm a Detroit kid, so automotive industry and all of that. So all of the supply chain things, have come rushing back to me. So all kinds of good questions. And I think you've already answered the first one, is the development of relationships with key strategic partners for whatever parts or sources of materials that you need. Not only, internationally, but with what we're seeing with this paradigm shift is, if business owners can find U.S. firms that provide lumber or provide component parts or, those types of things, that may be to their advantage. I'm thinking of suspect counterfeit parts, especially when you're dealing, with agencies, like NASA or defense or, energy. Those are critical things for suppliers or business owners to be aware of, is that they know who they're getting what parts from. We've seen, several things in the aerospace industry where that has been detrimental, to some programs as well. So I think you've already answered that part of the question. My finance brain goes into, is this an opportunity for businesses to think about purchasing companies that provide key resources that they need? That's kind of one thought that kind of came into my brain. Now, a startup, granted, most likely would need to focus on the development of relationships, right, to provide whatever kind of resources. But have you run across businesses that are saying, I want to go ahead and purchase this electronics company because they provide me with things I need to use for manufacturing, manufacturing initiatives? Have you run across that at all?
Or even forming like joint ventures, transferring assets, like manufacturing facilities. I've talked to folks about that, and not even in the industries they've usually worked in. There are people that are looking, like services companies, that are seeing the manufacturing push and the Buy American push and thinking about, well, look, things like, I don't know, pharmaceuticals or certain raw materials that might be manufactured, or certain components of the testing things that are manufactured generally overseas. Like, yeah. What if you bring them here and you just do the substantial transformation test under the BATA? You're bringing things locally and you're starting to do manufacturing here that's maybe less of a heavy lift, because all of the main manufacturing may be being still done overseas, but you've got the components that you're bringing in, and then you're assembling them or doing the substantial transformation here to trigger the Buy American, and it's under your company. Or, you're buying different facilities. All of those things are things people are definitely thinking about and doing in order to meet the needs of.
Okay. And then from the finance side of the house, my brain kind of went to spot buys for commodities. Let's say I need a lot of steel, or I need a lot of copper wiring. A strategy for a firm to go ahead and actually lock in on pricing for, I'll just say copper or steel. This would be more on the manufacturing side of the house. And then the joy of counter trade and barter. I want to purchase an airplane, and I have a resource of prime Russian vodka that I could go ahead and sell you, in exchange for a Gulfstream plane. Has anybody started down those paths with regards to manufacturing, or it would probably be resellers or commodity type buys, businesses? Does that make sense?
Yeah, I have not seen people take those actions yet. And I think there's been some reluctance on some of the sort of resellers or importers because of this risk that they think exists, that the government is trying to sort of go directly to OEMs and sort of cut out the middlemen. What I think you're going to see, though, is that the government's going to realize that there are only a few OEMs that actually want to sell direct to anybody, not just the government.
Right.
Most OEMs have resellers, and whether you're talking about Amazon or you're talking about, brick and mortar like Best Buy or whoever, right? The historic world was you would go to a store. The store didn't manufacture anything, and most of the companies that manufacture things don't sell direct because they don't want the headache, they don't want the issue. So I could see more of those sorts of things develop. I just personally haven't seen it yet. I don't know if Lauren's.
Okay. Yeah, it's very. Yeah, I'm sorry, Lauren. Go ahead.
Oh no, I was just gonna say I haven't either.
Okay, so it's kind of a very interesting time. So to be agile and flexible and kind of keep your ears to the ground to kind of listen for what's transpiring is going to be critical then for business owners moving forward. Is kind of the gist when it comes to the tariffs and how manufacturing is going to kind of pivot here within the United States. So is that pretty true?
I think for sure. And then when you layer on top of that, if you're like a serviceable vet company, you can't just form a JV with someone and have them do the manufacturing, right? There's different rules. If you're not the manufacturer, if you're just a reseller, you have to follow the non-manufacturer rule. If you are trying to do the manufacturing, then you're going to have to be doing, even if you're in a joint venture, you're going to have to be doing at least 40% of the manufacturing with your W-2s. So you need to be prepared for that. There's also rules about profit sharing and allocation of resources, so that if the government pays you, you can't reallocate certain profits to companies. I've seen questions about that. So we're still in a very regulated environment when you're dealing with government contracting, especially under the small business rules. So you need to be aware of that and maybe not get too far over your skis with some of the negotiations before you've really thought through things and talked to folks, like your lawyer or whoever, who really knows and understands these sorts of things, so that you're not spending a bunch of time and effort, and in some cases flying all over the world negotiating agreements that are going to be difficult to actually consummate.
Right. Got it. Yeah. Well, this is, I think, Cy, that's a whole nother Charlie Mike for you, the whole manufacturing thing. I'm going to toss that out of virtual training. So with that, I'm gonna stop here and I'm gonna say, everyone, we have more of PilieroMazza team coming our way to provide us with additional pearls of wisdom, like I like to call them. And Cy, Lauren, thank you so much for your time today and sharing your insights with our community. We really do appreciate it, and I look forward to number 2 in the very near future. And with that, everyone, I'm going to call this a wrap, and I'll see you later. Bye-bye.
Thank you.